Okay, so as I was saying, talking about the tariff wars, basically the push and pull between China and the United States, and basically many countries in the West at this moment is a question of intellectual property, brand identity, brand trust, goodwill, and related things. And in this particular case, China has already shared with us where many of these products are being manufactured, and the expectation is that people are going to order directly, but there's still a very strong pushback from people saying that they would rather trust something that has specific names on it because they attach the goodwill, they attach the trust, the credibility, they attach the standard of doing certain things to specific names. And even if those things are actually being created and manufactured in those particular factories, there is a sense of feeling that there is no quality control from the original owners of the brand monitoring the process. And because of that, most people will still rather buy overpriced items from brands that they trust rather than going directly to the factories that actually produce those things. And the reason for that, the summary for that is actually what we like to call intellectual property. And I'm hoping that for the rest of this masterclass, we're going to understand how intellectual property actually is valuable in our time as and in our space as engineers. And we're going to explain, or rather, I am going to explain the intersection of industrial design, intellectual property ownership, and ICT. And we'll do it in a way that will be able to ensure that they can safeguard all your creations while leveraging technology for better design outcomes. So for the next thing I'm going to do is to introduce myself. So like at the beginning, we've already heard that you've already gotten my citation and everything, but I just want to emphasize the fact that I am an intellectual property lawyer. I want to emphasize the fact that I am an intellectual property lawyer. Is there still a problem with my audibility? Is it just one or two people or everyone?
I think it's just one or two people. I can hear you.
Okay.
I can hear
Okay,
you.
so maybe, okay, thank you, sir. So maybe anyone that's not hearing me well, you can just either you leave and come back or work on the volume on your device. So I just wanted to point out the fact that I have worked with intellectual properties. As a lawyer, I have been in positions of registering intellectual properties, of negotiating intellectual properties, and that is what puts me in a position to be able to come and speak about their validity and how they can be commercialized for general economic growth. So with that, I will be plunging directly into what we're going to be talking about today, which is industrial design. Now, have it at the back of our mind that there are different kinds of intellectual properties, but as engineers, we're mostly going to interact with industrial designs. Of course, we interact with the rest, but industrial designs is something that I feel we should take a very good and close look at. Now, industrial designs basically safeguard the aesthetic and visually appealing aspects of your products. So if, for instance, a Coke bottle, let me use this mouse, the intellectual properties in the mouse are not just related to the things that the mouse can do, but also the way the mouse looks. And this is where industrial design comes in. So the specific design of the mouse that makes it unique, or should I say the unique features of this mouse are registrable as industrial design. And this is almost like a generic design for a mouse. So maybe I'll use this particular mouse. I don't know if everyone is seeing it, but this mouse, for instance, has a different design to this particular one. And the difference in the design is basically the industrial design. It's where the intellectual property comes in. Now, industrial design has a limited protection period. And that's why we notice that after a few years, everybody is copying the exact same design of a particular product. The reason is because the monopoly of that particular design is very, very restricted. And the reason for that is because the law believes that the monopoly should not last too long where other people cannot use it in their practical and functional daily lives. So industrial design is very valuable. But because the law believes it's very valuable to the general public, it has given us a very limited window to be able to register it. And with that at the back of our minds, since we know that we have only a very limited amount of time to have monopoly in that particular thing, then we have to pay good attention and ensure that we make as much money from that particular design within that window. And in Nigeria, the time frame that we can get monopoly over our industrial designs is 15 years. Now, unlike patents that protect the functional features of your technology, industrial designs only focus on the artistic part of your technology or your product rather. So we have patents that talk about the actual inventions, but for industrial design, we're talking about the beauty of it. So I'll give another example, the Coke bottle. We'll notice that for a very long time, the Coke bottle was not replicated by any other brand. In Nigeria, such a design is only have a monopoly for 15 years. But we have to have the back of our minds that different countries have different laws. So it's possible that different countries, depending on their laws, can be able to force that particular design, the monopoly, for even longer periods of time. But as a Nigerian lawyer, I will tell you that 15 years is the maximum amount of time that you can register. And the registration is usually 5 years. So this means that you register the first time and then renew twice. Now, have at the back of our minds that if we don't renew on time, you can actually lose your access to that monopoly. And the next thing I'll be talking about will be, sorry. So with that, I'll be going to the next slide, which is intellectual property. Now, like I mentioned, industrial designs are just one kind of intellectual property, but I pointed them out first and try to explain what they are because they are the most relevant intellectual property to engineers. But that does not mean that the others are not valuable. That doesn't mean that the others cannot be commercialized and be used for negotiation and even to raise money and other financial interactions. So intellectual properties generally are the intangible creations of our human mind and its expressions. Now, ideas are not intellectual property. It's very easy to actually mix that up. Your idea is not an intellectual property. The reason the law does not regard ideas as intellectual property is because many people can have the same ideas at the same time and at different locations at the same time and using it in different ways. So what the law actually protects is not the idea in your mind, but the expression of that idea. Now, expressions of that idea does not necessarily mean that the idea has to be expressed in a physical form that can be touched. The expression of the idea can actually be in any format that can be either reproduced or transferred. So when I talk about reproduction, I'll use an example of music. So if you express your music, that means you're singing it. You are recording it, let's say on your phone, and you can transfer that recording from one phone to the next. So that's the expression of that song and makes it qualified for intellectual property protection. For your design, you have to actually draw it out either on a tablet or on paper. And that should be capable of being either transferred from one place to the other or reproduced from one device to the other. That is what makes it qualified for protection. So, but another thing that is very important to intellectual property is that whatever you are creating has to be original or innovative. Now, that may sound like a contradiction to the idea that many people can have the same ideas at the same time, but it's not. So what the law is saying is that it qualifies something as original if no other person has expressed it before. Not that no other person has had the idea, but you are the first person to actually express it. So if, for instance, you had the idea to create a remote for an AC, as opposed to just using the wall switch. So many people may have already thought about, well, how can we create a remote for an AC? How can we create a remote for an AC? Maybe we can try this technology, maybe we can try that technology. But if none of them have actually created a prototype and you are the first with a prototype, then you can be said to have an original product. So that is what originality actually means. Then the next thing is innovation. Now, the reason now...
Hello, sorry. Do you want to questions as we go, or you want people to reserve their questions till when you're done?
Okay, I would like us to reserve our questions to the end because it's possible that I may answer some of the questions in the course of my presentation.
Okay.
Yes, sir. Thank you. So as I was saying, the next thing is innovation. Now, the reason why innovation is added to one of the prerequisites and not just originality is because a lot of things that need to be created have already been created. And most of what we're going to be doing is standing on the shoulders of giants, meaning that we're going to add to what is already in existence. So for instance, this particular design of this AC remote can actually be improved to something, to maybe a different shape. It could become circular with a different design. Doesn't mean that the AC remote is the first of its kind. So that's improvement on the design of the AC remote, even though it's not the first, is innovation. And I'm sure this is something that we're all very familiar with, given that we are all engineers or people that work with engineers. And so this is a very important aspect of intellectual property that qualifies it for protection. Then the next is that, like I already mentioned, it has to be saved in a fixed or transferable format. But the last is it cannot be contrary to public order and morality. This is when I like to give the illustration of people saying that they have to be nice to ChatGPT because by the time the robots take over, they at least may be safe. Now, the reason people say things like that is because there is a mindset, a prevailing mindset that technology can be used against humanity. So if you're creating something that is harmful to people, now not just harmful on the surface, like maybe harmful like a knife, that a knife can be used for good, it can be used to cut, a knife can be used to carve, or should I say like fire? Fire can be used to boil, fire can be used to fry, it can be used to do so many good things. It can be used to make metal, it can be used to create weapons, and it can be used to do so many things. However, fire can also burn. It can also destroy, it can also damage. We're talking arson, we're talking forest fires, we're talking different kinds of things. But something like that is not contrary to public order because it can be controlled. And the fact that that it's not controlled in certain instances is not as a result of its nature per se. It's just people that decided to mismanage it. But there are certain things that prima facie, on the surface of it, are for negative reasons only. And for such things, that is where the law draws a line. Now, the law does not describe in detail what contrary to public order and morality is. And the reason is because technology changes every day, and the law cannot anticipate every possible thing. And so the law gives room for judges to be able to make decisions and say, this new thing that is before me, this new technology that we are now exposed to, is it contrary to public order or morality? It's also a decision for a registrar at the patent and design registry to be able to say, before you can register this thing, does this thing actually, is it actually in favor of public morality? Does it improve public order? With that in the back of our minds, we have to create whatever we're creating. We have to have it at the back of our mind that this cannot be an inherently negative thing. Unfortunately, there is no standard for judging what is inherently negative, but that is where discretion comes in. And honestly, the discretion of the registrar, not just your discretion of the registrar, and also the discretion of any judge if you are being sued. That's if you are able to pass through the registrar. And so everything that you are creating has to be directly for public good, directly for public improvement of our economic life or the improvement of our daily life. And with that, I want to go to the specific intellectual properties that are relevant to you as an engineer, which is my next slide. So the first intellectual property, the most relevant after industrial designs, is actually computer programs. So we're thinking about system software, we're thinking about application software, we're thinking about different kinds of softwares, basically, especially as an ICT engineer, or like many people like to say as a tech bro or tech sis. So in that particular situation, the kind of intellectual property you're going to be creating in the course of your work, as you're working with algorithms, as you're coding, the kind of intellectual property you're going to create is what the law describes as computer programs. And these computer programs are can be registered as copyright, and not just copyright, but they are registered as literary works. The idea is that they can be written. Now, it does not necessarily mean they are written in English language or any spoken language, but the fact that they are programming languages that your software can be written in makes the law now describe them as literary works. So they're sort of like a work of literature. as long as the courts of law are concerned. And these works of literature basically are what copyright protects. So copyright is basically the intellectual property right that protects an intellectual property law that protects basic content creation. So we're talking literary works, we're talking dance, we're talking music, we're talking choreography. We're also talking in the architectural designs. So all those things, those creative, inherently artistic and creative things also protects the things that protect them. The law that protects them, which is copyright, also protects computer programs. And as an engineer, you should be very conscious of this. So when you are working, whether at a workplace or in school, know that if you're creating a new program or written in any programming language, you're creating a new app. It's not necessarily that you are inventing or even innovating those particular source codes. It's just your arrangement of them, the uniqueness of your arrangement. So it's very similar to other kinds of literary works, because I'll give an example for people that write in English or people that write in Hausa. No Hausa word, no English word belongs to any specific person, but the arrangement of those words is what creates a book. So the unique arrangement of those words, of those sentences, of those paragraphs is what the law will now judge whether they are original or innovative. It's the arrangement, not the individual words or codes or algorithms. No, let me not use algorithms, but not the individual codes themselves or even the commands that you are given to your computer. It's the arrangement of it, it's the uniqueness in the arrangement of it that you're able to use for. Let me give an example of something that is unique. So something like WordPress, right? So before WordPress was created, so I'm hoping that if anyone can't hear me very well, at least you can like watch the replay of this, because this is the loudest that I can get. I'm not sure I can actually scream. I'm actually at home, so I'm not sure I can scream. I'm sorry.
You are very audible.
Then,
You are very audible.
oh,
You're very audible.
okay, thank
So
you.
it most likely has an issue with his audio system. Just
All
check.
right.
Very audible.
So yes, so hopefully if it's not fixed, you can just watch the replay. So as I was saying, the copyright law protects our computer programs. It protects the unique arrangements of those computer programs. And there's something beautiful about copyright law. Copyright law protects your work, gives you monopoly for up to 50 years minimum. So you can have monopoly for 50 years of that particular computer program, or you can have it for up to 70 years posthumously. So that means that your kids, your grandkids, and in some cases, maybe your great grandkids may have continue to enjoy that monopoly even after you are dead. So it's your entire lifetime plus 70 years. Now, there are certain scenarios where maybe it's a particular it's a company that owns it and not you as an individual. And such scenarios is maybe when you are under employment, and your employment agreement states that anything that you create while you are working there belongs to your company. In a situation like that, then you can be in a situation like that, you can be your intellectual property does not belong to you. You are the author, you are the original creator, and that is where we talk about moral rights. But in terms of ownership, it belongs to your company. And when it's a company, someone that's not a human being, an entity that's not a human being that owns it, then it cannot be said to die. And so because of that, there is no 70 years after you die. In that situation, it's just 70 years from when it was first published to the public. And so basically, computer programs monopoly have a very long lifespan. And so you should guard them very well and ensure that you're not ensure that every single year of your lifetime, you are earning from it. We're talking royalties when other people use it. We're talking licensing fees when specific people license it from you for specific reasons. Or we're even talking sales, we're talking acquisitions, different scenarios, different financial arrangements that can ensure that you are earning money during your monopoly period. So enjoy the fact that you have that monopoly while it lasts. But that is where we're talking about issues like your employment agreement. What if you're a university student? What if you're a PhD student? What if you create it in school using your school resources or using your school time? what does your university or school policy say? Does it say that anything that you use during the time or resources of the school belong to the school, or does it leave that particular aspect of their policy blank? Or does it say everything that is created on campus belongs to the students? However, the school is entitled to a particular percentage of all revenue. So that is where you have, before you create, you have to be very conscious of where you are creating it, who you are creating it with, and at what time of your life are you creating it? Are you still a student? Are you an employee? And what resources are you using to create it? That's all has it all has a piece in the pie to show whether you are actually an owner, whether you can even enjoy any form of monopoly, or if all you're going to get is just a credit and maybe a particular award in your particular field. And with that, I will move into brand identity. So brand identity is protected by trademark law. It's basically the law that protects your right to appear a certain way, to have a particular goodwill. So it's still the same slide as the previous slide. For you to be able to have a particular goodwill, a particular reputation. So your trademark protects your brand's reputation. So we're talking about things like, do people know you? Do people know your products, that they always last? Do the people know your softwares, that they never lag? Do they know do they have this association with your softwares that they're a particular way? Well, the only ways they can attach that those characteristics to your software is if your software has a distinguishable name. So we're talking things like Linux, we're talking things like WordPress. Those things have they have a brand identity. And so whenever you're talking about any of their features, you attach those features to their brand identity. Even when we're talking about mechanical and hardware stuff, maybe things like Dell, we're talking about HP, those things also have the features that are attached to their brand identity. We're also talking about things like logos, talking about brands like Apple. So whenever people see the Apple logo, there are many people that not just know the Apple logo, they can describe to you how every single brand or model of Apple, the back of the model of Apple looks. So they can look at a phone and be like, even without turning on the phone, they can say this is an iPhone 16 or this is an iPhone 12 Pro. The reason they can do that is because the brand has carved a brand identity for itself, and it has created specific standards that people can now connect to that particular brand identity. And so this is where a brand identity comes in. We're talking logos, we're talking taglines, we're talking names, we're talking even smell, actually. Unfortunately, I'm not sure smell really goes well with the engineering industry, but in actual fact, smell, colors, and logos, taglines, names, those things can be branded, those things can be registered as trademarks, and those things can be enforced. So if you have your trademark registered, you can partner with agencies like customs, so that if they see any product that resembles yours but it's not yours, they can now flag it, they can actually seize it, they can also bring your attention to it so that you can now sue those people. And that thing I want to mention is that the intellectual property theft or infringement in Nigeria is both a crime and a civil wrong. This means that you can sue somebody for wronging you civilly, in going to civil court to actually sue them for damages, get an injunction, or many other things. At the same time, you can report them to the police and actually have them arrested. And in fact, under copyright law, those two things can be happening at the same time. So even if the only money you got from the civil case is 100K, they're actually liable to go to prison for 3, 4, 5, 10 years for infringing on your intellectual property. So they can actually pay you and still go to prison, and who knows, even pay a fine at the same time. So they can actually be punished up to 3 different times by paying you, paying the court, and going to prison. So it's a very, very sensitive thing. And one of the ways that you can enforce it is working with enforcement agencies. We're talking about the customs, because they are at the point, they are the border, they are the ones that receive a lot of goods as they come into the country. So you can work with them. You can also work with the police if it's for program softwares and things that are not physical. You can work with the Nigerian Copyright Commission. They can actually sue on your behalf. They can track down these offenders and sue on your behalf. So these are things that we should have at the back of our mind. These intellectual properties, computer programs protected by copyright, brand identity, protected by trademark, these things can be actionable in court. And these things are actual crimes. People are actually going to prison for this. It's just unfortunate that there isn't a lot of media coverage. So you hear an average Nigerian saying that, but it's not as if anything will happen to them. People are in prison right now because of intellectual property theft. And the reason is because intellectual property is regarded the same way as physical property. They belong to people. Energy is being expended to create them. Resources are being expended, whether monetarily, physically, in strength, or with your mind, whatever you are expending as your resource to create something, that thing is your property, and it should be protected. And we have to have the back of our minds that intellectual property, or rather that the right to own properties, is actually a fundamental human right protected by the Nigerian Constitution. And so because of that, it's not something to disregard very easily. Now, the next kind of intellectual property I'll be talking about is number 3, technological inventions and innovations. This is where patents comes in. Now, before I move on to patent, let me just mention one thing with trademark. Trademark can be protected forever. So unlike copyright that has a time period, 70 years after death or 70 years from the moment it was first created, or at the very least, in maybe a peculiar situation, only 50 years, trademark is different. Trademark registration is actually 14 years at the first instance, and then you can keep renewing it for 7-year periods forever. So this means that if your business should outlive you, your legacy business outlives you, it outlives your kids, it outlives your grandkids, you can still continue protecting that trademark. That is why nobody can use Coca-Cola, because the trademark is not expiring ever. However, you can lose it, and losing it is if you forget to renew the registration, or if you don't use it for up to 5 years consecutively, you can actually lose it. Or the issue of public order and morality comes in. If maybe the standard of morality changes by any chance, that is one reason why the law cannot give specific standards. If such happens, and whatever products you are creating is against public morality and public order, then you can lose the trademark registration, trademark protection of it. Now, within technological inventions and innovations, this is where actual innovations are happening. This is when inventions are happening. This is like the nitty-gritty of your work as an engineer, and it is protected by patents. So as an inventor, as an innovator, what protects you primarily, or what protects what you are inventing, what you are innovating, what you are creating, that is not a computer program, that's not in the ICT space, is actually patent. But patent also has the same argument as industrial design. Now, remember I said that patent is the functionality, while industrial design is the aesthetics. It has the same argument in the sense that these things should not have too much monopoly. One person shouldn't have monopoly over how a mouse works, or how a computer works, a PC works, or how a standing fan or an AC works. It is just not right. It's something that everybody should be able to produce, everybody should be able to sell, because it actually improves human life. And because of this reason, now, it doesn't mean that computer programs don't improve human life. It's just that they don't improve practical human life as much as patents and industrial designs do. That is why their protection is very limited, even more limited from patents, even though ironically, patent protection is 20 years. Now you only register once and you get protection for 20 years at a stretch. However, because of the sensitivity of patent protection, the government insists that you keep paying an annual fee every single year to prove that you still own the patents, that you are still using that particular patent. You get, and to an extent, what a registration does for you is that a registration is like a contract between you and your country's government, saying that you have to stand for me. You are my proof. You are my witness that I own this thing. And if anybody tries to take this thing away from me, or tries to use it and break my monopoly over this particular thing, you can actually stand as my witness that this thing, and you can even enforce it. That is why going to court and getting people locked in prison, because criminal matters is actually between the government and the offender. It's not between you as the victim and the offender. So you, the victim and the offender, you guys will sort it out in civil court. But in criminal court, is the government and the offender. And that is why registration is a contract between you and the government. And so once you've registered, once the government has signed and stamped that your registration certificate, then it's basically making a promise to you that I will enforce your rights in this thing. And this is what separates this from business ideas. This is what separates it from trade secrets. So trade secrets are basically your business strategies, your proprietary methods, your confidential information. But these things are different from all the other kinds of intellectual property, because in Nigeria, you cannot register them, unfortunately. So they are only as strong as the contracts that you sign them. And when I say as strong as the contracts, I mean as strong as the penalties that are inside the contracts. Now, your penalties cannot be prison. Your penalties cannot be things that are going against fundamental human rights. Penalties are mostly monetarily. So it's saying that if you break this confidentiality, if you leak this important information, our business strategies, our proprietary methods, our manufacturing steps, or our R&D notes, sometimes even before you create something or in the process of creating something, when you are going through research and development, you're going to have a lot of notes. And those things are kept secret until you are ready to create your prototype and announce it to the world. So what happens is that those things are protected by contracts, and the kinds of contracts are what we call NDAs, what we call non-compete agreements, so that people cannot use, even if you fire a particular staff or they resign, they cannot use that same information for your competitor or even for themselves. So those particular ones, because in trade secrets are not registrable with the government is not entering any contract with you. And so because the government is not entering any contract with you, any contract you're entering is between you and your employees, between you and your business partners, between you and your investors. That is another reason why we as lawyers always encourage inventors not to reveal too much whenever you're going to pitch things to investors. So try not to reveal too much about the technology itself. You can tell the investors what your technology can do in your pitch. And there's a way you can actually present it, especially if you're going on air for programs like Lions Den and things like that, where you go to pitch things. Even if those investors don't infringe on your intellectual property, the other people that are watching can try to copy it. And so it's very important that in your pitch documents, try to keep as much proprietary and sensitive information as possible. And in scenarios where they insist that you must share that information, make them sign an NDA. Now you're going to see a lot of investors, especially on social media, venture capitalists, make statements like, anybody that brings an NDA is not a serious person. They say it because they use it. And it's very simple. They thrive on taking advantage of people. And so they'll rather sometimes they'll take your ideas and then go and execute it with somebody else, someone that probably has a better brand, someone that probably, maybe, for instance, I'll just throw this out there. Sometimes some investors like to do a lot of virtual signaling. So maybe they want to tell the whole world that they're interested in climate change, or they want to tell the whole world that they are inclusive of like disabled people. So they would rather want to work with a disabled person that may not be as qualified as you. So they will take your idea, give it to somebody else to execute the idea, and then maybe give it to a disabled person to be able to present the idea. So it looks like, oh, we invest in disabled people. Now, this does not mean that there's anything wrong with investing in disabled people, but because some people do it to appear like good people, they don't do it because they actually care. They won't listen to, or even some, I've had similar scenarios where some people only wanted to work with me because I was a woman and discarded the value that I was actually bringing to the table. And so scenarios like that usually have two victims. The people that they claim to want to help are being discarded and their ideas are not really being spotlighted. And then the people that they believe know what they are doing, who are deprived of credit and deprived of acknowledgement for their work. And so because of things like that, it's very, very important to protect your trade secrets like your life. And since the government is not protecting it, since you cannot register it, you have to have very, very strong contracts. Now, in some countries around the world, the governments agree to actually protect, like maybe the United States actually has a registration system for trade secrets. But back to our industrial design. Industrial design, I'll repeat again, protects the physical hardware of your products, the physical appearance, the artistic appearance. And in fact, ideally, product designs are supposed to be protected by artistic works under copyright. But the copyright law makes a particular distinction. It says that if your work is a single piece of work or artistic work, it will be protected by copyright. But if you are going to make it for mass reproduction, then it's going to be protected by industrial design. So the idea is if you have a one-of-a-kind design, you can have a very large protection under copyright. But if it is something that has to be mass produced, the idea is that many people are going to need it. And if it's going to be mass produced, then the protection is limited, and that is where industrial design comes in. So that's essentially the difference between you and an artist. And you would notice that I mentioned earlier that under copyright protection, there is also protection for architects and their works. So for architectural works, the idea is that most times an architectural building is just a single reproduction. So it's just for a particular building. There are scenarios where this exact same design is replicated for an entire estate, but the law hasn't said anything about that, mostly because a lot of architects do not enforce their intellectual property, their copyright. And I'm hoping that it's something that is going to actually end in the next 5 years tops. And personally, me, as an intellectual property lawyer, I've made it my mission to actually educate and inform as many people, as many industries that are working with intellectual property as possible, so that we can actually be able to trade and take advantage of our intellectual properties to improve the African continent. Now, personally, I have a mentality, I have a particular philosophy that that when the rest of the world came to Africa because of our natural resources, now that they have control over most of our natural resources, they are moving slightly to our intellectual properties. Now, when I say moving, I don't mean that they have abandoned the natural resources. No, I'm saying that they are also extending themselves to go to intellectual property. So a few years ago, there were a lot of acquisitions of music in Nigeria, a lot of record deals, most of which are actually predatory. They'll just flash a lot of money just to be able to get control of our intellectual property. The same thing with our stories. A lot of our folk tales, a lot of our stories are actually being sold to film studios in California right now, but a lot of those deals are under just, a lot of them are being under the wraps. And the reason is because this is like my personal conspiracy theory. Africa is a very fertile land, physically and intellectually. And so basically the rest of the world is going to want to take and take and take. But before that happens, I feel that we should at least use it. We had gold, we had silver, we had a lot of minerals under the ground. The reason why, to an extent, why people were able to take it away from us was because we were not using it. But with intellectual property, with the right education, I believe that, especially after this particular masterclass, many of us are going to actually use the intellectual properties that we create, and we're not going to be in a hurry to sell it and just get like cash out, maybe just $1 million, $500,000 at once, and then forget about all the potential things that those people can do with it, and the monies they can use to generate, or rather the money they can generate from those intellectual properties to help their own economies. So with this, the next thing I want to talk about is why we should care about intellectual property. I believe that I've already touched on this a bit. Care about it because money. So a rich portfolio of intellectual property can increase your market value. It can increase your career opportunities as an engineer. Now, you may not want to have a business. You may actually want to work for other people. But if you already have like a rich portfolio of intellectual properties, you are going to get a lot of offers. A lot of people want to work with you so that they can at least get a piece of your pie. Then the next is to help you secure funding and investment. That is if you want to create a startup for yourself, or you want to build a business. Then it also helps us to stay competitive in the global market. I think I have explained this to a good extent. And then finally, contribute to national innovation and economic growth. Now, how to protect your industrial designs, and not just industrial designs, all of your intellectual property. Document everything. I'm talking about your R&D, your lab notebooks, your digital files. Ensure that everything has a timestamp. The reason being that people, like I said, many people can have the exact same idea as you, but you don't want to reveal the things that you have. So it's almost like, okay, how can I protect it and not reveal it at the same time? Especially maybe if my intellectual property is still in the baby stage. Make sure that you have a timestamp to everything. Use your phone recorder. You get our phone cameras, our audio recorders. They are not just for social media. They are not just for events. They're also for things like this, that they're actually a tool that we can use to protect our intellectual property. So document everything. Once you enter the lab, you notice that a lot of, I'm sure a lot of you already do it. In your lab notes, you usually have time saying that, okay, this is when this person entered, this is what I did, this is what I tried, this doesn't work, so I'm doing this. To an extent, when we're using technology, we can forget to actually keep track of everything we are doing. So the best thing is actually a video and audio recorder. The next thing is to file early, register on time. But don't register too early because, like I said, if your work is not, if you've not gotten a good prototype yet, and you register, the 20 years for patent to start running, the 15 years for industrial design to start running immediately. And let's say you may only be able to complete like 10 years later, meaning that you only have like a 5-year or 10-year monopoly period. So because of that, file early, but don't file too early. Now, I know this sounds like a trick, but this is where an intellectual property lawyer can actually advise you individually. So everything that I have taught so far is not legal advice. Okay, this is like a disclaimer. The reason being that there might be nuances, there might be intricacies, details about your personal work that I may not be able to have access to, or rather that I do not have access to at this moment. And so my advice is, or my teaching, my masterclass is going to be very general, very, very vague, and may not apply to you specifically. So this is where it's very important for you to get an intellectual property lawyer, not just any lawyer. The reason being that lawyers are not all the same. There are some lawyers that are energy lawyers. There are some lawyers that are real estate lawyers. There are some lawyers that are maritime lawyers. We have intellectual property lawyers, entertainment lawyers, and different kinds. So for your intellectual property protection, I want you to look out for intellectual property lawyers specifically. File early, register early, but most importantly, get an intellectual property lawyer. And with that, I want to say thank you to everyone. But I understand that in the time that I have spoken, I may have glossed over some things because of the time frame that I had to present this class. And so because of that, I will be introducing us to two materials that I have. Now, I have an ebook that you may be interested in that talks about intellectual property, that gives you a more holistic, detailed explanation as to what intellectual property is for an engineer. So it's specifically tailored to you. And I also have a course, a video course called Intellectual Property Valuation Fundamentals. But this is a little bit advanced in the sense that, well, now after you've read the ebook, after you've taken attended this particular masterclass, now that you would understand what intellectual property is, then the next step, the more advanced step, will now be to take a course on how to value the intellectual property. So it's one thing to understand that your intellectual property has value. It's another thing to understand how to value it, because there are actually formulas, there are actually steps that you can take to put a particular price tag on your intellectual property. And I'm sure you don't want to undercut yourself, because maybe you're getting excited at a particular amount that people in your industry may have never seen before. And to be honest, venture capitalists and general investors take advantage of this a lot. And so to avoid that, that is where the importance of learning how to value intellectual property comes in. But most importantly, I want you to read the ebook, watch this, attend this masterclass, rewatch it, because I'm very sure that it's going to be available for replay. Replay it, rewatch it, understand what I have said, and then read the ebooks as a guide, as a handbook sort of, so that it can explain to you the details of what I have said. And with that, I want to say thank you very much to the organizers. Thank you for having me here. And if you have any questions, I am ready to take them. Thank you very much.
Thank you so much, Barrister. That was a wonderful one, very insightful. Please, let's give her a detailed applause. Thank you so much. If there are any questions and answers, questions, contributions, observations you'd like to make, please just signify, and the floor will be given to you. Thank you. Any questions? Contributions? Okay, someone has his hand up. Okay. Please, Ibrahim.
Yeah.
You have the floor.
Okay. Good evening. Thank you very much for this wonderful presentation. I have a question to ask. In fact, I have two questions, but let me start with this one. I don't know, can I be heard?
Yes, sir, you are audible.
Okay. My question is, where does the original owner stand in the improvement of the product?
In the
I mean,
improvements of the product.
yes, like for example, you talked about remote, AC remote.
Yes.
If we have an original owner and we have an improvement of that remote, where does the original owner, what does it stand to gain from the improvement plan?
Okay, so it depends on the time frame. Within initially, let's say he created the remote. Let's say there was never a remote at all. So he would have the patent over the technology of creating a remote. Then the second thing that he will have will be the design of the remote. Now, for the technology of the remote, no other person can actually use that particular technology for 20 years. But for the design of the remote, people can have different designs of the same remote. But they'll have to get a license from him to be able to use the technology, that's the patent inside the remote. Now, after his 20-year period has expired, people will now start innovating. People will now start using the same technology as a source code or as a base technology to now innovate on top of it. But within the initial period is complete monopoly. So innovation actually comes after the monopoly period has ended. I hope that explains it. Sir, does it answer your question?
Sorry, Ibrahim, are you still there?
I want to omit. Yes, I'm here. Yes.
Okay, right.
Yeah, yes. That
Did she
answers
answer
my
your
question.
Okay.
Yes, that's okay.
Thank you.
You're welcome. But in the aspect of written or theory,
Yes.
if, for example, you have a write-up now, and I want to work on improvement on that your write-up and submit, I have to reference you.
Yes.
So,
yes. So there's okay. Please finish your question.
No, that's all. So I'm not saying that. How do you apply this now on the property or a product?
So patents and copyrights are inherently different. For copyrights in that particular scenario, there are exceptions to copyright infringement, meaning that if somebody uses your work for educational purposes to critique your work, or they use your work as a reference to create another work, then it's not an infringement on your original work. But it's very important that they must give you credit as the original author. So if they don't give you credit as the person that they reference, that's why you notice that academic fields are very strict on referencing. It's because not referencing is actually actionable and can be criminally prosecuted. So in that particular case, as long as they reference it, it's not a problem. It's actually not a problem, as long as the original one is still in your name.
Okay.
All right.
You.
Thank you very much.
You're welcome,
right.
sir.
So let me take this time to first acknowledge the presence of our pioneer chairman of this institute, Enya Augustine Wanene FNSC, and is the next person to ask a question. Sir, please, you have the floor.
All right. Thank you very much, Engineer Dara,
Yes,
the national chairman today. And the presenter, the resource person, you've presented very lucidly. I have not listened to this kind of presentation before, where the person is just rattling our brains. So my question is, where does open source softwares, the code for open source softwares, stand in the property business, copyright and code? Yeah.
Thank you very much, sir. I was actually expecting that. I'm happy that I didn't have to bring it up. So open source is actually, under the law, is described as copyleft. So copyright is basically saying that you have exclusivity under your creative works, that's your computer programs. You have monopoly over it. But copyleft is a voluntary waiving of that monopoly rights. But the thing with copyleft is that copyleft licenses are usually with a lot of strings attached, saying that you either have to use the technology a specific way, or maybe during a specific time frame, or only in specific countries. That is why when you want to use an open source thing, software many times, not all, because not all of them have this detailed license requirements. But for those that have, whenever you click on them, they'll first of all show you the terms and conditions that you should click on and accept before you can actually use. And if you break any of them, you can actually lose access to such open source softwares. Now, the thing about open sources is different from the public domain. Now, public domain just means that your exclusives have expired. But open source, it's still existing. Under copyleft, it's still existing. And anybody that uses it. So for instance, if Mr. Ibrahim now has a particular technology and he decides to declare it as an open source technology, and I use it, when I use it, I cannot now have any form of monopoly. I am not allowed to stop any other person from using it. However, any innovation that I make, like any new version that I create using that particular software, I can have exclusivity over it. But for the source code itself, I am not allowed to stop anybody using any form of technology to stop anybody from accessing it. In fact, some source code licenses insist that you must upload, like once you use a particular source code, you must upload it to a particular platform where anybody can easily access it, because it's possible that someone uploaded their source code to a particular technology, made it open source, and not many people know about it. So sometimes the requirement is that anybody that uses it must publicize the fact that it is open source, must publicize the fact that or how they were able to access it, so that every other person can access it. So I guess my answer basically to open source is that open source technologies usually have their license agreements attached to them. Not all of them do, but they usually have their license agreements attached to them. So before we use open source technologies, it's good to know the limits of that particular technology, the limits of use, and things that we can get in trouble for doing with them before we use them. But generally, open source is just a way of the original creator saying that I waive my monopoly rights. Thank you. I hope that answers it.
Yes, absolutely. Thank you very much.
Thank you, sir.
Thank you so much, my pioneer chairman, sir. All right. Any other questions, contributions? Okay, let me make my own contribution and probably ask some questions.
Okay,
thank
sir.
you again, our presenter, for that wonderful, insightful presentation. You know, it shows that you know the stuff, And like we said, this is one of the often overlooked pillar of innovation, because what I can see now is actually, I can see, well, you mentioned about the trade wars with China and America, and I can see what is driving that innovation. I can see that IP is actually driving innovation in that part of the world, because I was looking at numbers of patents. You know, if you look at the leading inventors and innovators in the world, they have a lot of patents and all that. They don't joke with it.
Yes.
And I think it pushes them to create more, and it brings in that competition. So everybody's trying to be the first to bring this thing out and patent and all that. And it drives innovation. I was looking at Elon Musk. I can see personally has 28. Jeff Bezos, like 336. Bill Gates, 365. OpenAI that just came in recently has 6. NVIDIA as a company has 5,000. So we can see that kind of thing. So I see the importance. But I would like to ask a question now. There's still some blur lines there. You talked about the IP laws. You mentioned copyright, trademark, and patents, right? And
yes, sir.
I didn't see the industrial design there. I want to just know how they all relate. I know you said a lot of things. Just if you can just say it short way, how the industrial design comes in the copyright,
Yes.
trademark, and patents.
Okay. So creative works.
Yeah.
Sir?
I said, looking at the Nigerian factor, what we have, what is obtainable here, processes.
Okay.
Yeah.
So copyright is protected by, it protects rather creative works. And for artistic works, it mostly protects one of a kind things. So the moment it's for mass reproduction, then it is protected by the design law. Now in Nigeria, the law is not just the Design Act itself. It's actually called the Patent and Design Act. So it's one particular document, that's one particular law that protects both patents and designs. It's just that it has different requirements for registration for patents and different requirements for registration for designs. So it says that for designs, which are very similar to artistic works, but because they are for mass productions, and they are very close to patents because they're usually for technical and functional things. For those industrial designs, they have protection for 15 years. But I just want to also throw in this, okay, before I say that, let me just reiterate that trademarks can last forever, and they are protected by the Trademarks Act. The Patents and Designs Act protects both patents and designs, and the Copyright Act protects creative works. Now, I just want to throw in the fact that many of these laws are territorial. So it means that if you register your trademark in Nigeria and you don't register it in Ghana, you may not be able to enforce that particular right in Ghana. So you see that a lot of these big national companies, sometimes they may not even have an office in a particular country, but they may register their business there and then register the trademark, the intellectual properties within that country, even though they don't have a physical office. Why? It's because they understand the importance of intellectual property. Now, most of the state of California, Silicon Valley, places an extremely big emphasis on intellectual property. And so because of that, an average startup founder is registering in multiple countries. That's why sometimes you hear that maybe the seed funding is a lot of money, but the product development is not that much. Sometimes the money goes into registering the prototype in so many countries, but not all countries per se. It's just the countries that they know that they intend to have business with. Now, copyright is what protects computer programs. And we know that computer programs pass through computers, right? They are not physical products. And so they are protected under copyright law. And because it can be very burdensome to register copyright in every single country, because how are you going to track the countries where people are going to use your work? So I'll give an example. Personally, my IP valuation course on Udemy has 735 students. Now, many of the students are from at least 30 different countries around the world. So imagine if maybe I wanted to register my intellectual property in that particular course video. Would I have to start going to each and every country? Because all of them have their different laws to register. But the beautiful thing about copyright is that we have international treaties that we have signed into. We have the Berne Convention. We have many other treaties as well. And what those treaties basically say is that the countries, our partner countries in those particular treaties, once you've registered in one, your registration can be recognized in the other. Now, for you to be able to go to court in that other country, you may have to do a registration, but you can actually stop somebody from using your copyrighted work even without a registration in those other countries. You can claim first foreign priority, meaning that even if you don't register there, you can stop them from having copyright because, you can always prove that their work is not original. And the reason you know it's not original is because you created it first in a different country. And so you can do that to be able to protect yourself in other countries. But more importantly, because we have treaties with these other countries, it's easier. By the time you go there, their courts will actually recognize your foreign priority. And so even the registrars will rather allow you register than allow somebody else that is a citizen of their own country register that same thing because your country is a treaty partner. So because I'm hoping that I didn't diverge too much, but I'll just go over it again very quickly.
It's fine. It's fine.
Yeah, okay.
I got it because of time. I still have one or two things to say because of time.
Okay.
So I was about asking that question of how relevant can your patent be in other countries? I wanted to ask, like for instance, if you get a patent in the US, does it supersede other countries, because of the world power concept and all that. But you talk about the treaty, and so it made sense. But I would still like to ask, like, registering. Okay, you said that's international, right? But like registering in the US, does it supersede every other country, or is still the same concept that there's a treaty with countries, and when you register in the US, it's relevant in these other countries that signed the treaty? And where does Nigeria stand in that circle of countries?
Okay, to be honest, it's not really the size of the country per se or the importance of the country. It's more, where exactly are your audience? Where are your customers? Where are your clients? That is what will determine which countries are more important to you. So the thing with the US though is that they are very quick to register because they know the value of intellectual properties. So it's very advisable that you register there so that you can stop the other people in their country from registering. Not necessarily because they are world powers, but because they are very proactive. That's the only reason you should register in the US. But in terms of importance of countries, I mean, the US because of how proactive they are, but other countries based on where you have like a high number of people that are willing to use your particular work. And we know that even if you protect yourself by using technologies that can stop people in specific regions, like geographically restricting technologies, you can say that, okay, maybe I'll use Netflix, for instance. Netflix is not available in certain countries in the world. So you can do that. But at the same time, have that back of your mind that VPNs exist and people can bypass these things very easily. And so because of that, it's important to register in specific countries that you know you have high demand in. And in a situation where you are not able to register, you can always go there. Let's say you register, you got to the country late. You can actually go there and you can challenge their registration. You can go to the registry and get their registration revoked, even if they've registered. But in terms of the US, just because they are very fast, they understand the importance of intellectual property. That's the reason why we have to register there, but not because their registrations are recognized more. No.
Okay. That's fine. Okay, I want to talk about something that happened recently. I'm sure you know about it. The issue with the ZAP Africa and ZAP by Pay Stack. I don't know if you heard about that story, right?
Yes.
Of course, I know you should even be very engaged in the issue. So when I read about it, I knew with your explanations now it's clearer now, but I wanted to see the issue was that the ZAP in the name. Now let's say I want to just understand how that plays out. The names in because they said the ZAP was copyright the
Trademark.
Paystack, was trademarked, by Paystack by the ZAP Africa first before the Paystack, and Paystack is trying to say that a lot of people have used that same ZAP in the names of their products even before both of them. There shouldn't be a problem, and theirs is ZAP by Paystack. So how does that play out, man? Just give us an insight on that.
Okay, trademark laws are a little bit tricky, but I'll explain it this way. Trademark registration is
sorry, man. Let me add one more thing. Sorry for cutting you short. Let me add one more thing.
Okay, sir.
We are talking about the name right now, and you mentioned the trademark. Then
Yes.
they are also dealing with computer programs. If you look at fintech and all that. So did they do copyrights too for their particular solutions? Then also add trademarks for the names. They just have that much. Sorry, I just wanted to add that so that right together.
Yeah. So, but in that particular situation, I don't believe the computer program itself was the problem. It was the naming of the program. That's the brand identity. Because unfortunately, people attach certain names to certain features, and so that was what we're fighting for. And the thing with trademark law, is that we have 45 classes of trademark. So, and those 45 classes of trademark represent different industries, meaning that if you register in the pharmaceutical industries, but you do not register in the ICT related industries, you cannot challenge somebody that is using that trademark in the ICT industries. So this is another reason why startups need a lot of money for their pre-seed run. And the reason is because they need to protect their stuff before they even go into full-on product development. That's when you now hear seed funding coming in. And so most people, especially big businesses, will register in like class 16, which covers basic branding, then in a couple of other classes that are related to specific products. So if, for instance, if Spacestack was in a totally different industry, they were not in the tech industry at all, maybe that's their defense would have passed. But because they are in the same industry, any trademark registration is going to be fighting for very similar classes. And apart from the law of trademark itself, there's a law of torts that talks about passing up. Meaning that even if you don't have any specific law against the trademark infringement, you can always say that they are trying to pass off their products as if it's your products. They're trying to build off of your goodwill to be able to generate income or build their brand. And so you can actually sue them, not just under trademark law, but also under the law of torts. But that is by the way. The main thing is that because they are in very similar industries, they actually had a ground to sue. They actually had a ground to make demands because they're in similar industries. And whether other people have used ZAP many times before, it doesn't really matter because it's not just the using of the ZAP, it's the context in which it was used. And in this particular case, it was used for a technology-related company. So I don't know if that answers the question. I was trying to be fast as well because of time.
Yes, it answers it very well. So are we saying that, I know the computer program was not the problem, but I hope they also have that have the copyright for that particular.
Hopefully. But at the same time, sir, for a lot of fintech companies, a lot of them use very similar codes to create their apps. And so proving originality may be a challenge.
Actually, so that's another point. That's another point to take on. We're looking at the open source that my boss talked about. And, people can now build on the open source codes and all that to come up with their own innovations. Okay, so that answers the question. I think that's fine. Okay, so my own contribution now is is a question and a contribution. At the present moment, how is the monitoring and control of trademark in Nigeria? Is it done? Is it still done manually? Do they have a portal now where they track from the end to end, from the registration to the updates that come through and all that? How is it done right now? Then I'll now add my own to my own.
Okay, so intellectual property bodies in Nigeria have their own tribunals. The tribunals don't actually monitor. What they do is that because the responsibility to monitor is on you, the intellectual property owner. So if there's any problem, you can now take it to the tribunal to be able to sort it out, especially if you want the matter handled fast, as opposed to the period of time where you can be in court for a very long time. So you can actually, but unfortunately, you actually have the responsibility as the intellectual property owner to monitor. But there are many startups that have positions, compliance officers, and part of the job description of some compliance officers is actually to monitor intellectual properties and monitor if any potential infringements. Now, I am an entertainment lawyer, and what that means is that I've worked with the entertainment industry for most of my career. And a lot of technologies in entertainment-related products, like maybe YouTube, have something they call the content ID. So the content ID monitors whenever you upload music or you upload anything on YouTube and you enable your content ID, what happens is that anybody that uses that same sound or uses that same audio, video, and uploads it on YouTube, they are going to flag it. YouTube is going to flag it and take it down. And maybe take it down for a particular period of time until they can prove that it is different or that they have the license from you, the permission from you to be able to upload. Or maybe they can just notify you and you can decide that, oh, I don't mind them using it in a particular way, and you just take off the restriction. So in the music and entertainment industry, I know that a lot of technologies are building to enable that kind of monitoring. But for trademark, for brand identity, I think it's going to be very hard because, I mean, what if your brand identity is being used in a country that you're not even aware of? But the main thing that business people do right now is that they focus on where they make the most money. So, for instance, Louis Vuitton is most likely not going to go to Aba to harass people that, or even get people arrested for infringing their brand identity by using the LV logo on products that are not created by Louis Vuitton. The reason is not that maybe Louis Vuitton is not aware, is that Nigeria may not be a very big market, or the people that they are selling those fake products to are not a very big market for Louis Vuitton. So the cost of them monitoring, the cost of them investigating, getting you to sue to court may be too much compared to how much they can possibly get from you and how much they are protecting it within that particular region. So they rather focus on people that are infringing in, let's say, South Korea, people that are infringing in Switzerland, people that are infringing in Ireland, or people that are infringing in the United States. The reason being that those are where their primary markets where they convert a lot of money, where they generate a lot of revenue. So unfortunately, there is no general way or should I say very efficient way of monitoring your trademark, your intellectual property. But one thing is for sure, it's very important that you highlight all the areas where you make the most money and focus on them. Then as you grow bigger, as your team grows bigger, you can now decide to expand. I mean, Disney as a company has the highest intellectual properties in the entertainment industry. They have the highest catalog of intellectual properties in the entertainment industries. Yet they don't go after everybody. But if you try to infringe their work in the United States, where they have a good portion of their customers, they're going to come after you very hard. But there are many other websites around the world, in Nigeria especially, many people download things illegally. They don't go after them. It's mostly because, I mean, if they go after them, how much money are they going to lose in the process of going after them? And how much money have they saved because they went after them? So things like that. That is why you need, apart from your lawyers, you also need financial advisors as well, or business advisors. Yes.
Yeah, so like you said, that you have tribunals, right?
Yes. Sorry, I stopped hearing you.
I think he
Hello?
dropped off
Okay.
briefly, but he'll be back. In the meantime, I have a question. What does it
The
take to
organization, last time I checked for the trademark
Okay,
and all that is the Ministry of Trade. Can you hear me now?
Yes, I can hear you now.
Oh, okay. Sorry. So I was asking that last time I checked, the organization responsible for the trademarks and copyright is Ministry of Trade and Investment. I hope I'm correct.
Yes, that's trademark, patent, and design. Yes, but copyright is an organization on its own. That's the Copyright
Okay.
Commission. They're
Okay.
independent.
So,
Yes, sir.
okay. So I was trying to say, how
Oh, sorry, the network has been cut off again.
do
Chairman,
they manage, or do you have a management application, like a
sorry,
software
we lost
application
you.
where they
Could
used
you
to
take the
track?
question?
Am I audible now? Yes.
Yeah,
Yes, you
but
are.
we
Please
missed
repeat your
the
question.
beginning
Oh,
of your
sorry, the
question.
call is entering. So I was saying, do they have like an end-to-end solution, where they track registration of copyright? I mean, even if it's the copyright organization or the trademark organization, to register, follow through the registration process and issue certificates. But I think last time I checked, it's done manually. They have to fill a form, submit, and all that. So I'm just asking,
Okay.
have they improved that process? Do they have that kind of
Yes. Yes, it's an online portal now.
online?
Although it's not 100% dependable yet, in the sense that you may still need one or two supports from them, but there's an online portal for the Copyright Commission. They've had an online portal for years. Their process is smoother. But for the trade and investment, that's trademark, patent, and design, they just rebooted a lot of things on their portal around January this year. So yes, lots of things are better now. They're lots better.
Well, I believe some of the solutions that can be used to ensure that for transparency and quality control is blocked. That I think or the organizations should look into that into the process for efficiency and more transparency. Yes. So I think the conversation. Yes, man. So it shows that the conversation has to, continue, because I'm still thinking about a lot of things that the impact you can have in our industry, in our sector, ICT sector, and in our profession as engineers. So once again, we thank you so much. This has been very insightful.